Hello, I'm Constitutional Attorney Katherine Henry, and this is a continuation of our mini-series on the 25 most commonly used terms in appeals cases. Objection. For such a small word, this one is so important. The taking of an exception to a question, answer, statement, or a procedure in the trial, intended to focus the court's attention on some allegedly improper item of evidence or procedure and to obtain corresponding relief. So if I think that the prosecutor is badgering my client on the stand, let's say this is a criminal case and I'm representing the defendant, and the prosecutor is badgering my client on the stand, I'm going to object. Objection, badgering, because that kind of behavior is not acceptable in a trial scenario. And I'm expecting the court to do something such as saying sustained, which means that they agree with me and they're telling the prosecutor, stop, do not continue what you're doing because it's an improper procedure. So the objection, though, is very important because whether the trial court rules in my favor or not, I have to lay that foundation in the record so that later on, if I want to file an appeal, the appellate court can look at the record and go, well, she objected to this happening when it happened, and the trial court didn't do the right thing and correct the error at that time. So now that gives us reason to correct the error in this appeal. Pleading. Another term that we've actually covered in all of our other videos on these definition mini-series, but it's super important, especially in the context of an appeal. This is the process by which opposing parties alternately present their contentions in writing, each responding to the immediately preceding pleading of the other party, thereby narrowing the controversy until a single point of dispute emerges called the issue. It is the issue that is resolved at trial. So that's more in the context of a civil case rather than a criminal case, because generally all the issues are just resolved at trial in a criminal case. But pleading is, in a civil case, you have your complaint, you have your answer, and then you might have some motions that are happening. Then you typically would have a trial brief that the plaintiff files, and then you have your answer brief that the trial brief of both sides, essentially. And once you have both sides submitting their briefs, then you have a reply that comes from the plaintiff. So sometimes you have just the initial documents that are, a complaint, and an answer might be very simple and straightforward, just a few pages at times. And then later on comes the full brief where there's, the full legal arguments and evidentiary support on all the issues. But regardless of how that particular jurisdiction does it, whether you do the full legal argument and brief at the beginning or, later on in the case, every single legal document where you're presenting evidence or you're presenting a legal argument, those are all pleadings to the court. Especially if you're asking the court to do something, definitely it's considered a pleading. Prejudicial error. Now, this is known as a reversible error. This is an error in the course of a trial serious enough to require an appeals court to actually reverse the judgment of the trial court. That's where the trial court or the trial judge messed up big time, either because of something that they did or something that maybe a witness or the prosecutor or a juror did that the trial court did not fix in some way. So that is a prejudicial error. Stay. This is the halting of a judicial proceeding by court order, telling all the parties involved, we're going to push pause. You can't do anything else until this stay is set aside, until there's something else that happens. So typically you would have a stay might be issued when one party is filing an appeal. So I asked for a stay in my Allegan County case when I filed my interlocutory appeal, saying to the trial court, you need to push pause on the proceedings here because I'm asking that the appeals court completely throw out this case because of all the defects here, the illegal ways that things are happening. And so I'm asking you to push pause at the trial court level while I'm getting an answer from the appeals court. So that's one manner in which a stay is utilized. Stipulation. That's an agreement between opposing parties or opposing attorneys on any matter relating to the proceedings or to the trial. So for example, to extend the time to answer, they might have a stipulation to adjourn the trial date. They might have a stipulation to admit certain facts at trial, etc. substantive law. That's part of the law that states, defines, or regulates certain rights. It's distinguished from procedural law, which sets forth the methods of enforcing the rights created by substantive law. So, substantive law, you might think of, for example, the right to bear arms. Now, that is in the supreme law of the land, right? That's in our Constitution, but that is an element of substantive law because it's saying what a right is. It's not saying how you go about enforcing it, or what the procedures are behind it. So you have procedural and substantive law. Transcript. This is the official record of the proceedings in a trial or a hearing. So typically speaking, you have a court reporter or some sort of electronic recording happening of a trial or of a hearing, and you would have that court reporter separately drafting. They're going to listen to the recording, for example, and they're going to be typing word for word what every single person is saying. So you'd have defense counsel, and you'd have the prosecution, and you'd have the judge, and you'd have witness number one and witness number two and the defendant, and so on and so forth. So anybody who is speaking at all is going to be, their words are going to be recorded onto the transcript. And typically you not only have page numbers, but off to the side, you will have line numbers. So you can refer to that later on in other proceedings, or even in an appeal. You can say, page number 22, line 14 of the transcript, you can see Billy Joe said, "Yes, I did it." And that is a transcript. Waive. That is to abandon or surrender a claim, a privilege, or a right. And how can you waive something? Well, oftentimes in a case, especially in a civil case, let's start with that. If you, in your first pleading, if somebody brings a lawsuit against you, and you are the defendant in a civil case, your first responsive pleading, where you are filing some sort of answer with the court, you need to raise all the legal arguments that you have, because there's quite a few of them that if you don't raise them in that first responsive pleading, then you are waiving them completely. So for example, personal jurisdiction. If the plaintiff is bringing a case against you in a jurisdiction where that court does not have personal jurisdiction over you as an individual for whatever reason, if you don't raise that issue right away, then that issue is considered waived, and you are considered as having said, yeah, it's no big deal. Go ahead and exercise jurisdiction over me. I'm going to go ahead and continue filing pleadings in this court and participating in this case. So that you can't raise personal jurisdiction for the first time later on appeal. You have to raise that in your first initial pleading with the court. So waive. And writ. Writ is a court order requiring the performance of a specific act or giving the authority to have it done. And you see this oftentimes. Some jurisdictions handle appeals differently. So for example, in Michigan, you have an appeal that's up for a direct appeal. You have an application for leave to appeal. Now, an application for leave to appeal in Michigan is similar to the process down here in Florida, where you file a petition for writ of certiorari, where you're essentially asking the court for permission to appeal what happened below. You're saying that there are legal reasons why what happened below is wrong, and you're saying, I know that there's no automatic right to appeal at this stage, but I'm asking the court's permission to take on this case essentially as an appeal. And so what that looks like is with my case with Ormond Beach. So that was with a magistrate, a special magistrate, and I had a statutory right to appeal, but that appeal brought me directly to the circuit court judge. That was my only right to appeal. Beyond that, when her decision came out legally defunct, I needed to request that the Court of Appeals take my case. And if it were in Michigan, it would have been done through an application for leave to appeal. But again, the process down here in Florida is that I had to file a petition for writ of certiorari, asking the Court of Appeals to take the case based on the legal reasons that I submitted. So writ. I thank you for tuning in to the 25 most commonly used terms in appeals cases. And I hope you learned from our series here, and that you continue learning in our other series that we have. We have one on general legal terms, one on criminal legal terms, and one on commonly used terms in civil cases.